Today's presentation is a part of several components of our rule of law discourse that Gary Jacobs and I have been working on for a number of years. And largely, I think it's Gary's inspiration to force me out of my disciplinary box and to attempt to look at the rule of law from a social process, anthropomorphic, value-infused, evolutionary perspective. And so the lecture is certainly an effort to integrate his thinking and mine in hopefully a relatively clear and possibly useful contribution to this MOOC. Now, I started with an effort to provide an evolutionary sense of the rule of law idea. And, of course, there are many different angles that you can use to elucidate this. And there is, in fact, a fairly conventional way of legally doing this, but I didn't want to follow that route. And so let me just start out by saying, as a matter of politics, law, and jurisprudence, the rule of law idea is actually a quite modern formulation of ideas that have been incipient in the evolution of law for as long as we can remember. And so the essential point being that the culture of things that look like law, the rules and principles and norms, that become more formalized, institutionalized practices and developments, are matters that have a strong evolutionary tone to them. And so they are intricately matted into the fabric of the nature of society, the history of society, and the evolution of society. And what is even more important is that embedded in this dry phrase, the rule of law, are important values that have had larger social process significance and practical value. So I wanted to just start out with a working description from a functional point of view of more or less what we mean by law. And essentially, the simplest way to look at law is to look at law as a response generated in society, usually from the collective, if you like, or representatives of the collective, to the problems that emerge from the give and take in social relations. So that law is invariably, it's not the exclusive response, but it's one of the most important responses to the problems that emerge from society. And so what we normally see then is that the image of law is that of contesting parties claiming what they consider to be their due, and this process of claiming may be relatively informal, or it may evolve into a highly formalized and professionalized way of presenting the claim for which you expect society or collective coercion and authority to help you. Now, the response to this claiming will usually come in the form of decision-making, and legal decision-making has many specialized features to it. But I would suggest to you that one practical way to look at it is that law is one of the most important instruments of policy. Not the only one, but it's certainly one of the most important instruments of policy, and that legal decision-making, therefore, frequently will partake of some of the most fundamental values encased in social policy. That at least is one way I would caution you that more conventional approaches to law see the word policy and immediately assume that policy is a political matter and not a legal matter. And I suspect that that objection will tend to obscure far more of the role and function of law in society than it is willing to actually concede. But we'll leave that for a moment and possibly for discussion. And so what we've connected law to here is 1, problems, 2, claiming, and 3, decision-making. I can even expand that a bit because I can say, well, sometimes claiming needs to be a more efficient way of staking a claim to valued things in social life. And if that's the case, sometimes the claimant needs an effective way of claiming. You know, you can't just shout in the street, I want something. You need a more effective way of claiming. And so if we unpack the architecture of decision-making, it may also, and this is a bit of an innovation to people who think in these terms, you may also ask yourself, but isn't there an architecture of claiming? And if you understand the architecture of claiming, you realize that if you're targeting the decision maker and you target your claiming to the functions of decision making that are implicit in the claiming, you may have a more effective vehicle for asserting and hopefully successfully vindicating your claim in the legal process. So now, one of the aspects of claiming is that you expect a decision-making response, and some of these decision-making responses which may emerge from society may come from circumstances that are purely expedient, and you can call that naked power. So that in society, collectively sometimes, decisions are made that are essentially moved by pure expedient considerations. We call it naked power. And we distinguish that somewhat from authorized or power moderated by authority. And so, but there are other forms of decision-making in which the element of power or coercion comes with the mantle of authority, within which the decision-maker will exercise a form of authoritative and controlling decision-making. And normally, even today, we tend to reserve the term law precisely for decision-making that comes with the combination of authority and control. So that, unlike some forms of modern theorizing where we want to make sure that power is completely obscured from legal relationships, we think it would be better to acknowledge the role of coercion as well as the role of persuasion or authority, and it's the combination of these two in whatever degrees for which we, in the modern functional sense, reserve the term law. So therefore, it's important for us at the beginning to recognize and have a clear conception of the role of coercion and the role of authority in our community response to the problems emerging from the give and take of human relations. In general, we tend to see authority as emerging from institutions constituted by the authority foundations of the community or state. And the shorthand expression for this is that there has to be some anterior authoritative or recognized symbol of authority. Usually and conventionally we say, well, it's the Constitution. So what we mean by constitutions are essentially, even in the most rudimentary sense, a constitution carries an expectation that is charged with allocating decisions about the fundamentals of decision-making in the community. So what constitutions are meant to do is they are meant to basically allocate decision-making power. And how that comes about is, of course, an important question. So that we frequently, for shorthand, will say, well, the Constitution authorizes the President, the Constitution authorizes the Congress or the Parliament. The Constitution authorizes the Supreme Court or the administrative agencies or whatever, or the individual, you see. And so that, in a nutshell, is that connection, if you like. The Constitution is usually the shorthand way of getting at the question of authority, but there's, of course, a great deal more. What I've said to you does not tell us how the Constitution was created, what social forces, what social pressures, what social understandings, and what social compromises all conspired to establish a basic understanding of the authorized allocation of basic governing competences within a community. That Constitution obscures all of that. It just assumes here's the authority, but obviously there's more there. So let me, the second part of this is to simply provide you with the evolution in the social process of constitutional understandings, the outcome of which will be a constitution, and if you like, the practice of constitutional law in the light of the Constitution. Now, it's well nigh impossible to traverse human history to a precise point when human behavior became subject to rules and moral principles and whatever, or the stuff that we call law. You know? And so we can make some enlightened assumptions. One of those would be, all right, let's just start with the notion that human society must at some point have emerged through the mechanism of micro-social institutions. And it will be apparent that in the life of a micro-institution, there would be certain needs that would have to be satisfied to sustain it. And those needs would need to be coordinated, and the micro-social institution would generate some normative understanding or some cultural rules about how these needs are to be met. They could involve needs necessary for survival, collecting, planting, storage, gathering seeds, whatever was needed, the making of tools and so on. So there would have to be some members of the microsocial group would be making tools, others would be harvesting seeds, others would be taking care of livestock, and so on. And so if you go back that far, you'd see then, in addition, the microsocial unit would then emerge with the complexities of procreation. And that represents a more complicated problem because procreative permissions or licenses within the microsocial unit will generally be productive of conflict. And so it was Freud that had the very interesting insight that we have to imagine that the first rules governing society came from microsocial units, and they came from the problem of how you manage sexual behavior within the microsocial unit. And in Freud's view, it was the notion that the father, the most powerful male, would dominate, and the other males would be precluded. And this was an undesirable circumstance, so mythically, the father is eliminated. Hence, the totem to the father, and the taboo, and the taboo meaning that sexual license between close family members is inappropriate. So the microsocial unit would have to relate to another microsocial unit. Exogamy becomes the basic rule. The incest taboo, we all know, is universal anyway, so that there is some plausibility to the Freudian hypothesis. And in this sense, you can talk about law and restraint as coming out of that kind of circumstance, which imposes some restraints and regulates the permissions of members in how they relate to each other in the group. Well, the we can take this, the rules about incest and exogamy further, although people do say that one of the important functions of the incest taboo was that it prevented genetically close parties from reproducing and thereby reproducing faulty offspring, but that may be an afterthought. So human relations themselves then become the generators of internal norms. They don't necessarily confine themselves to, as I said, the regulation of the incest factor. But given that microsocial groups will relate to each other, there will be a necessity for more rules, norms, standards that go to the question of human need, human convenience, and other forms of human conduct. And so we can say, and I think this is an important modern innovation of jurisprudence as well, namely that we can, with the right tools, detect the emergence of rules in microsocial situations. There is such a thing. Our former president actually talked about micro-law, you see. So we don't have to place the rules as coming from Almighty God or whatever. They came from the existential realities of human experience. Okay? And so that is still relevant today because modern jurisprudence has tended to say all law is exclusively the product of the sovereign state. And some theorists of the last century said, no. In all communities you have the state, but you also have other communities producing the law. Ehrlich, who's an Austrian, I think, called this the living law. And if you have the right tools, you can determine that in addition to the law of the state, there's the living law. And that idea has been expanded further, and Gary and I plan some future articles to develop that as well. But all right, so now we move from that to to the management of larger aggregates as exogamy becomes more important. And then the question moves from the management of larger aggregates. Well, that means that one of the components of these larger aggregates in their relationships to each other is that they cooperate, but they also conflict. And so right from the point at which microsocial units form networks of associations, the rules become more complex. And then what emerges from this is people need leadership. And there will be competition for leadership. And competition for leadership is going to mean sometimes conflict. And sometimes conflict can become lethal conflict. And so the pattern of conflict and collaboration are omnipresent factors of human coexistence. And we can see that, if you like, globally today, where we have a sort of an exogamous global scene where we have patterns of collaboration and patterns of conflict, and we haven't quite worked out a system as to how to expand cooperation on a global basis and to control, minimize, and manage conflict on a global basis. So we can take those ideas, certainly, and then we look at the question of what happens in the conflict scenario. All societies are going to generate some conflict. There will be conflict about the guys who want to be boss and the competitors who want to be boss. And if you have this competition, how is the boss to be chosen if the dynamics are conflict, then maybe it's conflict that makes the ultimate choice. But conflict is quite complicated. Sometimes one side loses and the other side wins, and that's that. But sometimes neither side wins, and the conflict continues with net losses on both sides. And usually in such a scenario, it's when the elites see that if the conflict continues, they both stand to lose considerably, that the idea emerges, well, maybe what we are fighting about is the management of power. So your first, if you like, notion of a constitutional understanding will be, where are the central points of power, and how can we divide them up so X gets that and Y gets that and so forth. And many important anthropological studies have shown that in many societies without a written constitution, if you have the right tools, you'll find that the society has a constitutional structure. One of the best studies of this was a book, The Cheyenne Way, written by Adamson Hobel and Carl Llewellyn, in which they described the constitutional architecture of the Cheyenne, soldier societies and the various, but it's a sophisticated allocation of power, and that means that everyone understands who's assigned to do what type of decision in society, how you change the membership of those institutions, so that there is a constitutional architecture there without a written constitution. So the point I'm trying to make is that you do not need a written constitution to have a constitution. And that also means that even in global society where we do have a written constitution, but a very weak one, it does not mean that there aren't sufficiently developed constitutional understandings that we need to better understand in order to appreciate the problems of maintaining international peace and security is one of those important things at the global level. And I just add one more thing. One of my colleagues died recently, but he wrote a couple of interesting articles on the constitution of small groups. And NASA had been thinking about what happens if we send people into a space trip for years and years and years. What will all govern them, you know? And my colleague was on this team that did a famous article called The Penthouse Astronauts, you know? And the whole point was you took an aggregate group of human beings, kept them in an apartment in Berkeley for 6 months or whatever it was, and then you studied them to determine how they worked out the management of the group, how they allocated the power between the group and so on. And yes, there is such a thing as a constitution of a small group, if you have the tools to observe it carefully. So law is a bit more rich in its anthropological and existential dimensions than we sometimes appreciate. All right. So what I've tried to say is, even without a written constitution, a community can find the mechanisms so that power will be distributed amongst the various contestants within authorized limits and so on, and so that the idea of a constitution is rooted in the principle that the constitution represents the expectations of an authoritative and controlling framework for the management of power in society. See, that's more or less what that relationship is between the constitution and the problem of managing effective power. I leave it to imagination to look at this globally. But now, just to take this and to spell it out more carefully, I looked at the question of law and the evolution of social process, and if you want to understand this better, you need to have a more articulate sense of what we mean by social process on a universal basis. And so I started out with whether you're dealing with a micro-social entity or you're dealing with a global notion of a community, you are still going to have some important markers that will permit you to describe at different levels as accurately as you can these social processes. So yes, there is such a thing in a family as a social process of the family with its own internal rules and markers and, if you like, constitution. But we can also use the same tools and markers to describe the global community and all the complexity of the different participators in it, not just nation states, but all kinds of other entities. So I've tried to use that just to stress the importance then of understanding the anthropomorphic and cultural salience of the social process context of the evolution of law. And we can just take that further to stress that the rule of law idea, which emerges from the social process then, is this idea that in the evolution of the understanding of basic social needs, the rule of law helps you to define how these needs are to be secured with a minimum of violence and conflict. That's what the general idea is. And then what's very specific about the rule of law idea and comes through in the specificity of the law viewed historically is that if a society is ruled only by considerations of naked expediency and raw power, then no one has any security over what they feel entitled to. If I were hunting and I brought an animal home, and when I brought it home, the boss decides just to take the thing, and that's it. You know? So people need some sense of what are my rights, what are my obligations, and actually in the history of law you see this consistently. Amongst the Romans, it was the patricians who used to just expropriate the plebeians, you see. And one of the most important, if you like, revolutionary demands of the plebeians was that their rights and their obligations shouldn't just be determined when the priest, the Pontifex Maximus, cut open the bird, looked at how the entrails fell, and then gave everything to the patricians. And that was really, in many ways, the origin of the so-called Law of the 12 Tables, where the rights of the plebeians were clearly articulated. And that, in a sense, was one of the most important foundations of what Roman law gave to global culture and civilization, the specificity of the specific kinds of interests that the law could secure, regardless of the emperor, regardless of the plebeian, of the patricians, you see. The very specificity. And it's my contention that in this specificity, the more specific and micro-detailed you are about what the law is regulating, the harder it is for the emperor to expropriate. So he doesn't know what it is. And hence, if you look at the history of Roman law, you'll find that it was a risky profession to be in, because you would define somebody's rights in such a way that would disempower the emperor, and 2 weeks later you're dead. Some of the great Roman lawyers like Alcuin were murdered by the top brass. So you see that, and then when you jump a century or 500, 600, 700 years later, in England, the King John believes in royal absolutism and that he can take anything he likes from anyone. And he takes usually from the class that has something that he can take from, and that's the upper class, the nobility. So it's the nobility forces him to a corner and forces him to sign the Magna Carta. And the Magna Carta, this is just a few generalities, it's a detailed list of things the king can't do. You know? Very specific. And so you see, if you go through another 1,000 years, what writers in the early 20th century said, when you look at the rule of law, the most important thing is England doesn't have a super constitution to limit anyone, but it's the judges and their interpretation of these very specific situations that are sort of beyond, if you like, legislative competence, beyond the power of the king to actually see. So the rule of law plays this quiet role in securing the rights of all Englishmen, you know, to have their property secured, to have their other rights preserved, to force the king to disgorge the body if the arrest has been unlawful, and so on, habeas corpus and so on. So that's sort of how the rule of law emerged, and again we see this a bit more clearly in the developed legal systems like the continental system of Europe, influenced by the Roman law and its casuistic approach to the details. And you see this in the common law and its casuistic approach to be case specific. And these are just hard things to to exploit, you know. And then you create a professional class of people, which the scholars in Europe and the judges in England, and all of those are buffers against the abuse of sovereign power. And that's sort of our rule of law comes out of those modest, if you like, elements of history. So what we see then emerging out of these, as I said, in England you had the initial thing was the form of action. How did you get a form of action? Well, the king wrote up a writ, and then the writ could be applied to all kinds of like situations. So the king set in motion something that he hadn't dreamt of. You see, the only reason he wrote the writ in the first place was he wanted the litigation to come before his judges, the guys that he appointed, so he'd control the system of justice. But the thing took off on its own, with the professionalized bar to figure out what a writ meant and how far you could extend it. And then cases were recorded, and then you had to follow the cases that were recorded. So the scholars had a role to play in this, and so on. And again, even in the context of the continental tradition, it was during the Napoleonic period that people wanted to know much, much more explicitly what their rights were vis-a-vis the state and so on. And so Napoleon said, let's codify all this common law. Let's bring the scholars in and work. He's a very democratic king. It limited, as I said, power of the state and so on. So, yes, and so I've used some illustrations from Roman law, from the Anglo-American tradition, and of course the Americas, the American Revolution overthrew the colonial monarch, repudiated the king's claim to sovereign absolutism, and it established the idea that this republic would be based on the rule of law as well. So those are the things that we've had historically. Now, when we come to the 20th century, it's obvious that the great inheritance that we got from the 1500s is the way in which sovereignty, the notion of sovereignty, had evolved. And so from the scholars, Bowden and Hobbes, we really get, not that they were necessarily partial to sovereign absolutism, but they were also not particularly happy about anarchy, and so it was quite a useful thing to centralize and make the king the sovereign. But then this idea of the sovereign having all of this power, rationalized by the fact that maybe the power came from God. God has basically validated the exercise of sovereign authority without limits, except as recognized by the king. And so you find that there are some challenges to this, of course. The earliest of these challenges was the King Charles I in England's claim to sovereign absolutism, and he was met with the chopping block. His head was chopped off to make the point that sovereign absolutism was not appropriate. And from his beheading, we got the notion of parliamentary sovereignty, that the role of the king would be a bit more limited. In France, of course, Louis lost his head to the French Revolution. And in Russia, of course, the Tsar was also eliminated because of his claim to some form of Tsarist absolutism. But the most important development in the notion of sovereignty and sovereign authority and the possibility of sovereign absolutism really emerged from the scholars. John Austin, the English jurisprudence man, wrote a very powerful theory which rationalized the effects of sovereign absolutism. And that was to identify the law and the state as one. And that means there wasn't any room for anything else. So some writers in the 19th century said, well, jurisprudence is the burial ground of international law. Because if the sovereign's absolute, where's the sovereign for international law? It doesn't exist, you see. And so from then to now, odd nation states still seek to subscribe to a notion that the sovereign and the law are one. And that any law that purports to limit the sovereign is really not law. That's essentially the Chinese view. I think to some extent it's largely Mr. Putin's view. And it survives with Abbas in Syria and Gaddafi and a whole range of Stalin was using roughly the same idea. Hitler was using an exaggerated form of the same idea. So the power of this idea, notwithstanding the events of the Second World War, has stuck. And so we live in a world today where a significant number of states still see themselves as sufficiently sovereign as to be beyond the notion of international law, or beyond human rights, or humanitarian law, whatever. That is still there, and it's grounded in a very powerful theory. It's a theory that's easy to understand. You identify a sovereign, the sovereign issues orders, he backs the orders by threats, and that's law, you see. Now, of course, there have been theoretical challenges to this, but that's an easy thing to understand, and politicians will look at something like that. That's exactly what we are, you know. And so that is the great challenge of the 20th century when monarchy was beginning to fall apart, and the idea that war was a tough thing, and it never was confined to a few state actors. And the worst of all of this was the First World War, where it just seemed as if great powers fell into war like lemmings, you know. Some lunatic shoots a nobleman in Sarajevo, and then Austria wants to teach another society a lesson. Russia wants to come in to protect its little brother. Germany wants to come in to protect the Austro-Hungarian Empire. France comes in to protect Russia. Britain comes in to protect France, Belgium. And the whole world goes into... You stumble into a war without any restraint, without any thought of its consequences, its lethality. It's global. This is a war that ends up beyond anyone's expectation as a global war. And in many ways, some historians say that we are still conditioned and deeply influenced in our tactics, our strategies, and our thoughts about the condition of war and peace by the events of the First World War, by the way it was conducted, etc., and the weapon systems that were developed from it. So that was the First World War. Two statesmen considered the absolute horror of this event, and they were Woodrow Wilson and Jan Christian Smuts, who was the South African statesman. And both of them independently came up with the notion that maybe there should be an international organization to guide and coordinate global sovereign understandings. It was the Wilsonian version that prevailed. He brought America into the war, and he came to the peace process with a 14-point program. In fact, it was published before the war ended, and the Germans very much decided that they could get a good deal out of the 14-point program, so they're quite willing to agree to the ceasefire on the 11th of November, 1918. But in the actual negotiations at Versailles, it was quite clear that the Allies, that is Britain and France, wanted their pound of flesh, and Wilson's 14-point program was radically weakened, to the consternation of many people in Europe, certainly. In any event, a League of Nations was created, and the League did a few things. It limited the notion that you could use war as an instrument of conquest and acquire territory that way. And what it did was it simply said, all these German territories are not going to be given as a gift to the Allies. They're going to be put under a regime managed by the League of Nations. And that regime was called the League of Nations Mandate System. The Palestine issue in the Middle East is one of the residual problems that still continues from that period. And but in setting up the League, largely concerned with global peace and security, there was one problem. By this time, at least theoretically, everyone had bought into the idea that sovereigns are the exclusive makers of law and therefore makers of international law. If a single sovereign objected to an act by the League of Nations, the League could do nothing. Because the League was not a sovereign body, only the sovereigns could make laws. So when the Japanese went into Manchuria and were condemned by the League, the Japanese said, no, hell with you, and they just walked out. By walking out, they basically stopped the League in its tracks. Mussolini went into Abyssinia, ditto, and so on and so on. And so, essentially, the League of Nations then was a casualty of the problem, which was largely a problem generated by legal theory, by scholars, namely, that the sovereign is the monopolizer of all lawmaking, which essentially means that there can't be an international law unless a sovereign specifically agrees. And if one disagrees, there's no such thing. Now, we can speculate about whether the League of Nations would have been strengthened if the United States had actually not defeated in the Senate the U.S. participation in the League of Nations. That might have changed, and perhaps there would have been some effort to change the rules that were being utilized. But the U.S. was the only power that wasn't sympathetic with those rules anyway. And with Woodrow Wilson's death, this didn't amount to very much. So we just stumbled into the Second World War then with an international institution technically committed to the maintenance of international peace and security, but literally having virtually no legal imprimatur to it because of the theory. And, of course, for many states, the practice, because if you say you're sovereign, Hitler, and there are no restraints on your sovereignty by law, then that may well be a very convenient construction of whatever law has to offer, at least in the global environment. And so you can say then that we stumbled into the Second World War with its over 100 million casualties, with its death camps and concentration camps, and with its invention of a new phase of war called total war. And quite clearly there were lessons to be learned here. And here the U.S. Did play an important role because it already indicated, even before it came into the war, that if we were coming into the war, Churchill would have to agree to something called the Atlantic Charter. The Atlantic Charter contained something called the Four Freedoms, so that World War II then, when the United States came in officially, was a war that was fought to maintain and secure the four freedoms globally. That's essentially what it was. Whatever the legal status was of the so-called Atlantic Charter, from Roosevelt's point of view, he felt you could not ask all these young people to come fight and die for nothing. You know, there had to be something there. And the four freedoms were the freedom of speech and expression, freedom of conscience and belief, freedom from fear, and freedom from want. And those four freedoms, or those four principles, form the conceptual basis of the United Nations Charter. And, of course, those are political principles. They happen to have been agreed to by the liberals in the U.S., that is Roosevelt, and by the conservatives in England under Churchill. And somehow or other, Stalin didn't think one way or the other. I think he thought all of these could be reconcilable in his view, you see. But nonetheless, this then became the foundation for the creation of what I think is the first global constitutional mechanism, that is the UN Charter. And I think in the history of humanity globally, we have had more action taken under the umbrella of the UN Charter than in the entire history of humanity. Today. In the entire history of humanity, there's been more global action taken under the authority of the Charter than ever. We can talk about the UN Charter. We can talk about, quite seriously, an International Bill of Rights. And we can talk about an immense range of treaty developments in race relations, gender, children's rights, environmental rights, and so on. So that we do have, it's not as if we are in search of a roadmap of the things we need globally, but we don't have the mechanisms of enforcement and the mechanisms of agreement with the principles that most people would say, oh yes, we all agree with that. You know, we all agree that torture is wrong, torture should be criminalized. But then, you know, you have slippage. The United States started to have its black sites and various players. When you look at Amnesty International's figures of some years back, everyone says torture is wrong, but at least half of them are doing torture anyway. You know, so that creates a problem between the prescriptive form and the practical mechanism to secure compliance. So the question then is that the UN Charter is today I think the best codification, that at least from an historical point of view, of the values behind the rule of law. So we have a real stake in the Charter, in its efficacy, and so on. Of course, there are many problems with it. Is the Charter meant to be a document that is largely concerned with protecting the sovereign state, or does it have a broader mandate? The introduction to the Charter says, not we the states, we the people. It talks about, in the second or third paragraph, it's there to protect peace and security. The third one is there to protect fundamental human rights. It's, you know, rights of women, rights of races, and so on. And it goes on. It spells these things out. But there's clearly a tension between whether it's a state-centered instrumentality of global constitutionalism, or whether it has to account for a much larger participatory constituency. And that is the great challenge. It's not as if it's clear, because there are many contestants in the global environment that do not like non-state participatory involvement. And so that's a challenge. So where does WAS fit in? What intellectual role can WAS play in giving a much more precise definition of the Charter? Should we engage in a study and do the political work behind it for reform of the Security Council? What are we to say when the Council is blocked by a single veto and the threat to global peace and security not only continues but becomes very, very dangerous, especially if there's a prospect of a nuclear or weapons of mass destruction confrontation? So the problem, of course, with the rule of law is that there are consistent challenges to it. It's not an inert concept. There are constituencies that do not like the idea that they may have to be constrained by rule of law precepts, some of which may be much more explicitly developed through the international institutions of governance like the UN system or the European Union system and so on. So some of the rules are fundamentally contested in the context of the Ukraine, for example. Frankly, what you have is a challenge to one of the most important principles of international law, at least since the Second World War, and that is no state is permitted to acquire directly or indirectly territory at the expense of another state by the use of force. This is a clear rule as you can imagine. And in fact, there was such a consensus on it that when Saddam Hussein invaded Kuwait, the entire UN said, you can't do this. That's absolutely wrong, and permitted a US-led invasion to expel the Iraqis from Kuwait. This is a well-established rule. It wasn't a rule that was cooked out of nothing. It was basically a rule that emerged from the fact that so many wars are fought for territorial aggrandizement. And the one thing you do not want is, to mobilize your forces, change borders willy-nilly, and so on, and stoke up. So it's true that there's a consensus on these fundamental and other values, but it's also true that they're contested. When we had the unfortunate circumstance here of Serbian aggression in Croatia and Bosnia, another way to look at that was they felt that they could do what they were doing because they could get away with it. No one would enforce the rule of law against them. See? And it was a quantum leap to finally set up a tribunal to try the war criminals, to actually say these things count and we will try to enforce them. It was an important lesson because the other side of what Milosevic and these other guys were doing was to challenge the most fundamental things that 100 million people died over from the Second World War. So even though you have a constitutive process and a constitutional architecture, it doesn't exist in a political vacuum. It's something that has to be fought for, and not just with governments, but with every available well-meaning NGO, with every well-meaning group of enlightened intellectuals. And so these are things, or this type of constitutive process, this conception of the rule of law is still a matter that is contested and still has to be fought for. Well, that's the first of these lectures, and let's see if I have anything else to say here. Yeah, that's it. So, Ivo.
Thank you, Winston, very much. Let me start by saying something that none of you know, namely Winston, more than 20 years ago, came to this country, where, of course, the country was in a rather bitter and difficult situation, and he participated in, I believe, 3 of the so-called Noel Baker Pauline Pechet conferences that we had. And all of law that I know, Winston taught me this 20 years ago. So of course, I never got a grade, so you can't say it anymore. Later, of course, this lecture that you presented, I have two questions. You pointed out, of course, that what we have is a UN Charter, but you specifically, very properly use the word international law. What we would like to do is to have a global law. And as a matter of fact, our fellow, who you also know, Mr. Broad, now published a book where he argues that there should be a global constitutional court and a number of these things, which is, of course, is a different thing when you speak of international law, which is the law primarily dealing with states and sovereign states, and there comes, of course, out of that comes the international law, while, of course, the global law will be something that comes from the famous sentence, we the people.
We the people.
We the people. And the question is, how do we come to this? My other problem, and again, is this definitely you taught me when you informed me about the book by Jamal. According to Weller, of course, the only one who has the monopoly of violence is the sovereign states. And then when you look at the data are that wars are responsible for 1/3 of the killed people, while the sovereign states killed 3 times more of their own
people. That's right.
Their own people. And there is something there, which is hard to really swallow. I mean, less to digest,
Yeah.
So, okay, your comments.
Just on the global law thing first. Now, there are a former president of WAS, Harold Aswell, had also thought about this, and he talked about global public order. Global public order, which was his version of global law. But what he tried to do was to sustain this by an effort which Gary and I are now trying to reinvent. That is to say, well, if you want to have the notion of global law, you first of all must have a much, much better understanding of the global community. You've got to understand who the participators are. You've got to understand the role of the significant players in political economy. You've got to, in other words, you've got to have an identifiable sociological description of all the participators, the gangs, the terrorist groups, as well as the Red Cross and the WAS and so on. You really have to have a picture of global society as it is.
Which we don't.
Which we don't. That's what we try to do now here in WAS. We try to map it and all these things. But that's sort of what we're doing. And we've gotten, I think we've made significant inroads in economics, for example, and we're working on some other areas. And probably the problem in the Ukraine will be an opportunity for us to broaden that out more effectively. But certainly, you can talk about global law, but if you have no concept about the global social process behind it, then you don't even know which problems you're going to be dealing with, how you're going to be dealing with them, what the possibilities are of reshaping the framework of global institutions. How do you modify them? That's one of the issues. And that's partly academic, partly intellectual, and so on.
But there's not an academic question. Who is the enforcer of the global law? Who is going to play the role of the state to enforce it?
Okay. Yeah, and the state is, of course, an abstraction from reality. So then we have to, the whole point about understanding the social process is to understand and who exactly can be an operative player or players in the critical nation states. How can they be mobilized and and who is the target of their mobilization, the point which I was making to Gary. And I confess I've been working on some of these issues, and the groups that to give you one example, I was trying to work on the children's issue, and I was with about 10 of these groups. So I mapped out a strategy. I want to know who's opposed to the Children's Convention in the Senate Foreign Relations Committee. Okay? And of those who are opposed, how many of them are vulnerable electorally? How do you put pressure on the specific guys? But the truth of the matter is, none of these groups wanted to hear this because they were funded and they expected a project to go on for the next 20 years with the funding. So to solve this problem now would not be in the interest of. And then I dropped out of it. This is quite clearly not what I was going to do. But this is the harder problem is to target, and that's the second issue here, the global social process. But then you also have to understand the precise points of leverage in the global process of effective power. So you can't have a law that's completely ignorant of where the points of leverage are. And that also requires a degree of mapping and so on. See? So we know which institutions can target which institutions, and perhaps people like us can play a role in clarifying those things, mapping out strategies and tactics that may be effective. So that's the second part of global law, is not the global society. Out of global society, there's going to be a complex configuration of institutions of power, players, and so on, and they're all interacting in a somewhat anarchic way, but we have to understand it if we're going to change things. It's out of those two processes that you can then ask yourself, well, what are the possibilities then of understanding the global constitutional process, not as it's written in the UN Charter, but as it's actually operating. Then you can try to change the Charter or trigger those mechanisms that will make it fit to how it's actually working, and then try to improve the actual workings of it. So it's not an irrational agenda, but it's a big agenda, and it's a challenging agenda. So then you can't just work in the US, you have to ask yourself, is China changing? What are those social forces in China that we can work with? How can we clarify the interests of China so that they may see that, their short-term interests that they're protecting are a way of undermining their long-term interests, you see. And so, again, we need a lot more, what is it that has motivated the Arab Spring? Have we quite understood it? Have we understood the role of religion or the power of religion? And how does it work? And how can we have it reshaped so that we can tell people over there, well, look, ISIS is not Islamic. They're the most un-Islamic group coming out of that place, Yeah? And so on. So the notion of a global law requires us to do these things. You can't just say, yeah, I want it, and then, it's like a pie in the sky. But that's the hard work that I hope we will stimulate in the academy on multiple practical and theoretical dimensions. At least that's that. Now, I didn't get your second question again. It was the first one was so gigantic.
The second question was related to this, namely that the states are being now the carrier of violence. Graham's studies that you taught me.
Yeah, that was, and the shocking thing is that the sovereign state with its unlimited power is a mass murderer.
It's a mass murderer.
And so when we ask ourselves about the new paradigm, I always focus on, what do I see in the structure of global governance in which the state is still a central player, but what do I see there that whittles away the omnipotence of this power? You know? And the only thing I see is that we have the growth of a global civil society, but it's yet uncoordinated, unmanaged, and somewhat underdeveloped.
And to follow on this, of course, an anonymous book gives data on Holocaust, Gulag, and so on. But
right.
There's another thing, namely, as a result of, for instance, the 2007 crisis, economic crisis, the result of this economic total failure, there are people killed.
Yes.
Killed not literally, indirectly. Starving to death and so on.
We haven't asked we haven't done the intellectual work that goes to the human cost of this.
Absolutely, yeah.
But so our agenda, I think is virtually scripted for us. I mean, there it is. All we need is our fellows to be energized and to get on with it, Sorry.
But you make an example. The king signed the Magna Carta. Nowadays...
He didn't do it voluntarily, okay?
Right. Nowadays, there are nations like Maldives that thanks to the pollution of other states are losing the country. Or there are, exponential demographic growth that is a big problem, and fascist and Marxist-Leninist dictatorship united with the Catholic Church have been preaching and convinces millions of people that it's important to have a large family. This, produce untold suffering, wars, and damage everybody. How are we going to be able to have the king sign other global and sustainable Magna Carta? Because, it is a pressing answer that we need, because the things are getting worse and worse. And what is the credibility of law if the most flagrant crimes don't even have the name of crimes?
Well, I'm not going to contest what you say because you're right. And you've underlined, of course, the limits of law, the limits of understanding. But even there again, what we see in so many sectors of society are contested domains. Okay? So we have women in many countries are saying, look, we want some control over our power to choose about when to have children and how many. And then you have the church saying, you shouldn't have that power. It's a power to be allocated to the priests or to, whoever, And then you have the state saying, well, the more children you have, the more resources to exploit we have. So, but those are contested domains. We haven't taken up as many of these within the academy as we should. We should be having far more seminars globally on these things, on the most contested domains, okay, about human values and the future of human values. So, you can't say because it's a contested domain, we in the academy will not touch it. Mm-hmm.
Well, we don't have the global system law, but we have the patchwork of global laws.
Yeah.
And the law, like other rules and institutions, require strong incentives to build. So this is not the coincidence that we have WTO with the rules. This is an example of the law. We have European Union law, means we are discussing about TTIP, Transatlantic Trade and Investment Partnership, it will be type of common law, common standards. So which will have a Transatlantic, Trans-Pacific, similar. So it will be really type of, still patchwork, but somehow raising the standards and then bringing the rules. So the situation maybe is not that hopeless as we think. We know that we have a global economy. All economies are intertwined, and then the incentive, economic incentives are so strong that we are building this system. We don't have such strong incentives in other areas, human rights. So this is why the environmental issues, this is why we are missing in this area that type of global regulation, global laws, and then enforcement mechanisms. So the WTO is pretty good in enforcing the laws. There is a stick. Even China has to respect this. Not always. You can go to court and then you can impose penalties, or at least, get some warning.
See, one of the great challenges in the economic area is this. You start out with the state, and the state enacts the law or it inherits the common law. But the reach of that law pretty much stops at the state's borders. Now, what it is that most huge companies want is to function outside of the authority of the state, but not within the authority of something like the UN. In short, they want to have the rules, but only rules that benefit themselves.
Yeah.
You see?
Exactly.
So you have to, that is another, even within the US, the biggest battle in the Congress, led by Elizabeth Warren, has been anyone taking a hard look at the way in which the credit card companies are functioning, or the mortgage companies and so on, will actually find that most of the stuff they've put in there are really illegal. Mm-hmm. Okay? But now what you've got is, we're not going to declare it illegal, although it is, but we're going to actually prevent any governmental institution from taking action on the illegality. Okay? So a huge chunk of the commercial culture is at present thriving on illegality, And if you say, well, it's got to regulate it, regulation is communism.
Yeah.
So
that's, this is just typical
manipulation. And that's another. And these people spend millions and millions on lobbying to make sure. Yes. Yeah.
Very briefly, I think we're just going to the error where the whole definition and the meaning or the weight you attach to the concept of law has changed. And I find that laws are not effective, and that in essence, the powers that be can manipulate laws. They
have a better chance of
they manipulate international treaties, they manipulate, so we're talking about laws, and laws are something we're supposed to uphold and we're all supposed to respect. But right now, in this period of humanity and history of humanity, the laws are being formulated and they're being governed by the 0.1% club.
Yeah.
And the courts, the judges are being chosen and picked, not for merit, not for independence, not for impartiality, but by those very powers that be. So, what do you suppose?
Well, I think what you've illustrated is not a conclusion, but it's a contested domain, you know. And what I'm trying to say is part of what people like us can do is to begin to look much more carefully at those contested domains and then consider what we can do to moderate. We're not revolutionaries in this sense, but at least we can sit by and do nothing, or we can try to do something.
Yeah.
Thank you very much for your presentation. At some point you said that constitutions have to do with expectations, that is with anticipation. So the law in this sense is not only a framework for regulating past experience, but it's also something that helps us in looking forward. And I think that this is a major issue, because it means that the law may include aspects that help or that will become obstructions towards what may rise. And I think that one of the big, not one, I think that something that may be relevant for the World Academy and more generally for all us is that we should have the courage to address big issues, not only to address the technical. Well, we need, of course, technical expertise and whatever, but there are major transformations, major changes in front of us, and we should at least try to see fragments of what is going to happen, or some of the trends that are unfolding just now. Just to mention a few of them. And the interesting fact is that we see different big trends in different parts of the world. So the immediately subsequent question became, is there anything unifying them, or are they just like a patchwork in which different okay, leaving apart. In Europe, we see something that is very important from an institutional point of view. The idea of state in Europe is starting to lose weight. We are at the same time moving towards two different architectures. Mm-hmm. From one side towards more regional institutions, and on the other side towards continental side institutions. And the traditional idea of state, is powerful, they are the major players, whatever, but year after year they became less convincing in a sense, with only one remarkable exception, that is France. France is the only real centralized state in Europe. All the other European states are facing troubles. They have internal movements for independence. In Spain, in Italy, UK, in 2 weeks' time there is the referendum for Scotland and so on and so forth. So these movements, so far, they are still not coordinated with one another. Some of them are left-wing, some of them are right-wing. They are very different. But nevertheless, all the states, or the European states, but France, they are facing troubles. And so we can start seeing this double movement. But that's just one idea. In the Muslim countries, we see something that is no more thinkable in our place. There are people willing to die for God. That's not a trivial issue. In Europe, in the US, probably nobody is willing to die for God or something like that. Maybe a few centuries ago. But now, we may die for money, not for many other things, not for God. At least in some of the movement within the Islamic countries are so shaped by this kind of values that they are almost, for us, it's almost impossible to understand what's happening there. Most of the news we read on the newspaper, what's happening? Because the basic conceptual framework is so different from the one we have been developing during the past few decades. We will know that finance is very important. Okay, and it has been the source of many troubles. There is that incredibly interesting movement of local monies. I mean, currencies without a central bank behind them. Mm-hmm. That's something completely new. They may survive, there may be, so far they're just local movements, but they may include, big regions in some parts of the world. And that's also something pretty out of the rules. Something completely different from what is expected. Finally, democracy. What is democracy? I'm not sure I understand democracy, in the sense that the basic ideas of democracy are 2 centuries old. Is there anything new there? Are we tracked to what was seen 2 centuries ago? Or, for instance, democracy for us is representative democracy, the way in which democracy has been shaped in Western countries. Probably that the tools we have today make possible some kind of direct, of participatory democracy, at least for some aspects of social life. That will change the way in which we take decisions. And all these are new aspects. They are very different from one another. I'm not saying it's the same movement that is shaping. They are different from one another, but possibly there may be something, if we dig deep enough in the various threads and try to understand what's happening, maybe you are lucky so that we can understand, well, there may be some similarities, there may be some unique force. I don't know what is there. What I'm saying are big question marks we should start to address. And perhaps by using both the past and future possibilities as a source of inspiration, we may find, we may develop ideas on whatever, we may have an influence. We may try to do something that we do, versus.
Well, I like what
it's not a question of talking.
No, I like what you said, because it endorses the notion that we need a much more effective and discriminating way of understanding. I use the global social process. There are many components of it, that the currency issue, how does it, and in fact, I don't know of any recent studies that have really rethought sovereignty in the context of the European Union, in a functional way. It's distinct from that. So those are things that are happening right now, regardless of what we've said. And then I agree with you. We don't understand the Arab world, that's for sure, and we don't understand whether some of the fanatic religious groups are marginalized and being exploited by others, or whether they are something genuinely, Sorry. Okay?
Roberto, I think you made an important comment about that the law reflects not only the forces of the past, and we know the law in many respects is a conservative force that is used to preserve things at a certain level. But we also know that it reflects values and aspirations of the future. In order for us to understand the future of law at the global level, I think there's a lot more I would like to understand about the process of law as it's developed so far. Mm-hmm. And I've been thinking back to what you told us and what we've been discussing this week. Society strives to accomplish, human beings strive to accomplish goals, mm-hmm. or realize values in your terminology. And we organize our relationships in order to do that. Mm-hmm. And at a fundamental level, law is a social organization mm-hmm. that facilitates and extends our power, our collective power, mm-hmm. to relate to one another. Mm-hmm. If without law, I can lend money only to somebody I know personally and I trust. With law, I can lend money or borrow money, for that matter, from anybody within that legal framework wherever they are in the world. So law is an enabling institution at a fundamental level that generally empowers us to a certain extent in some context. It is an empowering instrument. It also is supported by the power of the society. I think you mentioned it briefly, and maybe you'll come under the evolution of law. What used to be done through violence is sublimated and done through in a non-violent way. But the power of the society, which was once used violently, is now sublimated into a legal system with enforcement apparatus. So there's power that creates this institution, and this institution also empowers and facilitates many other institutions, many other activities. You briefly touched on the issue of micro-law. In fact, you touched on many different dimensions of where the power comes from that generates law. Whether it's the Magna Carta, whether it's well, Jeremy was talking about conformity. When a society accepts the authority of a king, even without being compelled by violence, when we accept the monarch as our symbol, as our identity, by subjecting ourselves and conforming to that, we empower that monarch to create law. In the case of, so conformity comes into this in some way I don't fully understand. In India, during the freedom struggle, the thing that struck me so much about the history of Indian freedom, and not that it's exceptional, but was that India, I think India could have been free in 1905 if the population had really decided they wanted freedom and they needed freedom. The real power was not that Britain had, a huge army that was suppressing the population. The real power was what Johnny was talking about. The population accepted the privilege of being the jewel in the crown of the British Empire and thought they were elevated by that. And to a very large extent, even when freedom fighters started asking them to rebel, they didn't want to. They felt the joy or privilege or prestige of being part of the system. So I know you're going to come back to this, and I'm trying to lead up to what you're going to speak in your next talk. But when you talk about, if we're going to talk about how do we create global law at the global level, one point that several people have mentioned this afternoon, you and Ivo and others, is that the development of law and the development of political institutions are intimately related to each other. That's clear. And we see the problem when we're trying to regulate international finance, that we don't have the institutions with the authority, and we're trying to empower institutions so they can create law. So the problem we have with global rule of law is global governance as well, and they go together. They're inextricably interlinked. But do we understand? I don't understand, that's what I'm asking you. I think the more we understand the role of the society in the generation of law, that's why I like the story of Rosa Parks, which we've written about so much. Because that's not only the role of the individual, but she embodied the attitudes of the society, and it was the society that rose, the black society that rose and said, no, this is not acceptable, and the law was changed. So we know there are conservative forces of the status quo that are reinforcing law as it is, whether it's the gun law or the laws of corporate finance, of elections in the United States. But we know that's not the only power that determines law. And so if the more we can understand about the social process that Lazaro talks about, that is the fundamental basis. Our laws may be the result of our conformity and acceptance of the status quo. Our laws may be evolving because of our changing attitudes and values and our demands. which is a term you're frequently using in the future. So I think in your next talk, focusing on the social process and its relation to the power process and the legal or constitutive process will really help us in this discussion of what can we do at the global level where the institutions are informed. This morning, while you were recovering from the lightning strike on the plane and other mortalities, I gave the example of the American Civil War and the role that Lincoln played in that. And it was very clear to me that the U.S. government did not have the power to abolish slavery or to unify the country, in fact. They got the power to unify the country when the army began to finally win enough victories. And he converted that military victories into an affirmation. He couldn't have done it if there wasn't widespread social endorsement. And it wasn't unanimous at all.
Yeah, right.
Tremendous tensions there. But if there wasn't sufficient social support for that. So, but it's not because the institution of the United States of America and its government was all powerful. It wasn't.
No,
it was very, very precarious. And it could have gone one way or another. So we're in a situation now globally where we see the global institutions are extremely nebulous. We certainly don't see any global political consensus of the states as how they should act. But we do know that there is a rising sense of social awareness, of a greater social inclusiveness. I don't know what it is or where it is in the process, but if we understand the power of the society, and if we understand where the global society is now, we may get a much better idea of what will work at this point. Lincoln's genius was he knew better than anybody in the cabinet or anybody else where the society was and what they were ready for.
Right.
And maybe Ivo and I a couple of years ago were talking about, I think it was Roberta, you mentioned, one of you mentioned the idea of a more direct form of democracy or something like that. But we've already talked about in the Academy and written about the idea of global referendum. Global referendum will work if there are themes on which there's a global consensus. Not unanimity, but where there's sufficient global consensus to support it. So I hope in your, I really enjoyed this, and I hope in your subsequent one that you can focus on the real relationship between what we see emerge as political and legal, but what is the social basis for that? Because at the global level, I think that seems to me the thing that's got to come first.
Right. Well, I think you're right. As I said, the agenda is fairly substantial, but we have to start somewhere, and a deeper appreciation of the global social process and all its components may give us a better shot at predicting the trends in sovereignty, the trends in regional, the trends in private sector development, the trends in human rights and so on.
Our mapping it will certainly give us an idea of the complexity.
That's right.
The dazzling complexity of it. But maybe what we really need is the intuitive perception of a Lincoln who really senses what's possible.
Yes. I'll have a shot at it. But with your help, maybe we.
Yeah. Great. Thank you. Anybody else? We've had a very full, great discussion today. Thank you very much.